Justice Gorsuch?
You're not going to like these questions any better than those. I do want to follow up on that. I actually think you probably have a pretty good argument on the statute, which focuses on job function, whether it's executive or administrative. And I kind of took the dissent in the Fifth Circuit to focus on the fact that tool pushers are administrators, and that's just the nature of their job. And I think that's probably all right. But the regulations are all about pay, how you're paid, the mechanics of pay. And we've been down to the minutia of that for the last 40 minutes. And I just don't see that argument presented. And I just want to give you your one last shot on why it isn't forfeited in this case.
So it's not forfeited in this case, Justice Gorsuch, because the case has always been about whether ultimately the respondent is exempt under the statute.
No. The question we granted cert on was whether you had to satisfy, 601 and 604 or both, right? That's what we granted cert on.
Absolutely. And I'm not trying to pull a bait and switch. I'm just telling you, at bottom, the case is always about the statutory exemption. Where the circuit split, and what we haven't run away from, is the circuits are split as to whether 604 essentially conditions and modifies 601.
Right.
We don't think it does, for all the reasons we put forth elaborately in our brief.
Put that aside, though, it seems to me quite an independent question whether 601 and 604, either of them have anything to do with the statute or defy the statute, which is, I think, what your argument might otherwise have been.
Well, here's what I think we have argued, and I think this is fairly. Our argument is if 604 is not incorporated, then 601 is more consonant with the statute than if 604 is incorporated.
Okay, I understand that argument. I understand that's before us. Okay, and with respect to that, I told you you're not going to like any of these questions. You're not going to like this one either, okay? The circuit split we took up was whether you needed to satisfy just 601 or both 601 and 604. Okay. You've heard a lot of questions today about whether you even meet 601. And let's say you don't, okay? Let's say you don't. And you lose right out of the starting gate. And so the circuit split isn't even implicated. Your choices at that stage are either to answer the 601 question adversely and send it back, or to dig. Which do you like better? I told you weren't going to like the question.
I mean, I would prefer that you just answer the question, because I don't think there's a basis for dig. And I think if you look at the cases on the other side of the circuit split, you will realize that there is no difference about whether we satisfy 601 versus those cases. Because all that's different in those cases—
No, I understand you think you're going to win on 601. I got it. Let's say you lose on 601. Would you rather that? Would you rather hear that answer, or would you rather a dig?
I'd rather hear we lose on 601, but the statutory question's still open on remand.
I don't know if it is or not. I mean, you didn't raise it here. That much I'm pretty sure about.
Because there wasn't a circuit split on the statute.
No, I know. You wouldn't have gotten here.
But in fairness, I mean, if there's an embedded premise that somehow this is different from the First Circuit or the Second Circuit case, I do want to address that, because those cases involve the same basic issue, which is somebody whose pay is calculated on an hourly basis, which is a concern of 604, but have a weekly guarantee, so they're going to get at least $1,000.
I got that.
Okay, so if Judge Winter's wrong too, and we're wrong, and then you should tell us we're wrong.
Okay.
You shouldn't dig it, because there's still a circuit split.
Got it. Thank you.